Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about how to establish paternity if the father did not sign a voluntary acknowledgement of paternity at the hospital. So let's first talk about what a voluntary acknowledgement of paternity is. When unwed parents have a baby at a hospital, the hospital provides them with a form called the Voluntary Acknowledgement of Paternity. This is known as a VAP for short, for obvious reasons. The Voluntary Acknowledgement of Paternity, if the parents agree that the father who's at the hospital is going to acknowledge that he's the father and the mother wants to accept this acknowledgement, they can both fill out and sign these Voluntary Acknowledgement of Paternity forms, and the hospital will add the father to the birth certificate. And when this happens, the father is immediately obligated to pay child support. You still have to establish what child support is going to be, but establishing paternity obligates the father to pay child support, but it doesn't give the father any rights to parenting time and responsibility. If the father wants to get rights to parenting time and responsibility, the father will have to file a petition to allocate parenting time and responsibility and open up a court case to show that it's in the best interest of the child to have the father have parenting time and responsibility. And this is very easy if the parents can come up with a parenting plan and agree to it. It's a little bit harder if the mother wants to allow the father to establish paternity so that she can receive child support, but does not want the father to have parenting time or contact with the child. So in that situation, there's going to be a court hearing that determines the best interest of the child. But I digress. So the point is that if everyone's in agreement at the hospital to establish paternity, at least for the purpose of child support, then the father will fill out the VAP, the mother will also fill it out and sign it, and the father will be added to the birth certificate at the hospital. But what happens if for some reason the father can't be at the hospital but wants to establish paternity, or does not sign it at the hospital but later wants to establish paternity, or if the father does not want to establish paternity but the mother does for the purpose of receiving child support? So we'll first talk about if the parents are in agreement and they didn't sign the VAP at the hospital. Well, this is very easy. You can get a VAP form online, fill it out. Each party has to sign it in the presence of a witness, and then you submit it to the Illinois Department of Healthcare and Family Services, the IDHFS. We in the article associated with this video on our website, we have both a link to the form, and we also have the address that you're supposed to send the form into, and the form also has instructions on how to fill it out. So you can go to learn-about-law.com to get both the form and the place that you send it in. But if both parents agree and submit this form to the IDHFS, then the IDHFS will basically send it to the proper department to get the father's name added to the birth certificate. So there won't be any more steps that you have to take to add the father's name to the birth certificate. And this can be done at any time after the birth of the child. So anytime the parents can come to an agreement, they can sign the VAP, send it into the IDHFS, and get the father's name added to the birth certificate. And then this will obligate the father to pay child support, but it will not necessarily give the father any parenting time. If the father does not want to establish paternity, or the mother doesn't, if the parties aren't in agreement, then either party can file a lawsuit and file a petition to establish paternity. And we have an article and video about paternity law at learn-about-law.com that goes into detail about how these lawsuits work. But the bottom line is that a hearing will be held at which each party presents evidence for and against the paternity of the alleged father, and usually the father will be asked to take a DNA test, and this is the best evidence, although it's not dispositive. It's not the only evidence that the court will consider. It's weighed along with the other evidence, but it's weighed heavily. If the father refuses to take the DNA test, the court is likely to rule against him. So you don't have to take the DNA test, but if you don't, you're not likely to win. So at the end of the hearing, the judge will decide whether paternity will be established in the alleged father. If the judge does so, then you can submit that order to the proper department to get the father added to the birth certificate, whether the mother agrees or not, or whether the father agrees or not. And we have an article and video at learn-about-law.com about how to update the birth certificate once you've established paternity. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices in several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.